we started the captive insurance company in January of 2020 and had COVID soon thereafter. And so it's been a unique experience starting a company like this during that time period. But I think us, and along with all of our insureds, adapted and found a way to make that work. And so we're real happy to be here. With me is Leah Check and Dennis Yanishevsky. Leah, you can go ahead and introduce yourself if you're, I don't know if she was able to get on yet or not.
Yep, I'm on. I'm just working on some the video issues over here. So I'm just not going to log back onto my cell phone. But I'm Leah. I am the national sales lead for the Villanova Stagers, Designers, and Organizers program, also called our SDO Pro program. So what my role is specifically is that when we receive applications, I'm the one that's doing like the underwriting work on it, providing the quotes, making sure they're competitive, and making sure the insurance is tailored to exactly what you're looking for to be able to cover your business and your assets appropriately. So, and then there's a couple other individuals on our team, and they kind of deal with renewals and that type of thing. But I'm basically the point person for when you first are looking to get insurance and all your questions.
Excellent.
And then Dennis Yanishevsky works with me directly. He's one of the attorneys on my team of claims managers and risk managers. So Dennis, go ahead.
I'm Dennis Yanishevsky. I'm associate counsel at Villanova. I handle a lot of the staging matters in terms of consulting with stagers, designers, decorators, organizers, and a lot of contract assistance and any pre-claim sort of risk management that needs to happen.
So Dennis works with me directly and does a lot of the work now on the agreements themselves. And so we'll talk about it in a little bit, but we have agreements that we've created to give to all of our insureds to use. But some of our insureds want to use their own agreements that they've had and they're comfortable with, or they had their attorney draft it, whatever the case may be. And so in addition to providing the agreements for free, we also do edits and reviews of our insured's agreements for anything. And so Dennis takes the point on a lot of that work for me, and really has a strong handle on, you know, the ins and outs of the contracts that are appropriate for your work. And then Leah obviously knows way more about this insurance program than I'll ever know. So you may hear me defer to her from time to time. My area really is risk management. After that, you know, that takes up enough of what's left up here after 54 years that there's not much else room to go. So it's great that we really, you know, our magic really isn't products, and it's this team. And I think we have a really excellent team in place to help you with all your insurance needs and certainly your risk management.
Yeah, the last thing we want is a problem there.
No, definitely not. Definitely not. Let's see here. So if you want, I can flip it over and take over the screen and put the slide deck up.
Let me get that going for you. All right, you should be okay now.
Okay, let's see. Here we go. Okay, so you should be able to see the slide deck now.
Yeah, excellent.
All right, there we go. There we go. Okay. So again, we're going to talk a little bit today about insurance for home stagers, designers and decorators, contracts and subcontractor agreements. We did speak a lot about COVID-19, as you can imagine, over the last 3 years, but there's really not much to talk about at this point, other than we created special riders for staging and designing and decorating contracts to deal with the ins and outs of being able to access the property, who can and who can't. And I know there's still many people who are, you know, have to take these precautions, you know, the same way we had to take them in 2020 and 2021 for their own reasons. And so I'm sure from time to time, you know, in your work, you're going to come across people who, you know, want to keep those same protections in place. And so we have an agreement that lays that out that we created, but we're not really going to touch on that too much today. Unless anybody has any specific questions about that stuff, then, you know, I'm happy to answer them. But this is all the contact information here, our direct dial number, the website address, and then of course Leah's email address here, because she would be your point person to kind of walk you through the process and show you what products we have in terms of insurance and fit those products to match your needs. So Leah will always be the point person on that, and that's her email address there. And I'll try to remember to put the slide back up at the end, but certainly I can email you, Lori, I can email you and just give you the contact information too to pass out.
That'd be great.
So Leah, if you want to just talk a little bit about the products and services, because that's first on the agenda here, and then I'll go into the contracts.
Yep.
I'll
no
work. I
problem.
can work the slides for you too. Just let me know what to do.
Awesome. Happy to do it. So how it works is once we receive your application, we're always going to provide you with a quote for general liability, also called like a business owner's policy. So you'll often see the acronym BOP. Of course, insurance has to make everything difficult and have multiple names for everything, but the general liability business owner's policy, that's the quote we're going to provide you for. And what that coverage is, that's going to cover you for your client, like for when you're working in a client's home. So any damages that can occur there, such as like a theft or a fire. And then it's also going to cover your inventory while you're working in the home. So that's going to be when you're staging inventories at that stage location, when it's at your storage location, and then when it's in transit from those two. General liability also is going to cover when an innocent third party, so not yourself or anyone you bring on the job, but if it's a real estate staging and there's a potential buyer walking through and they trip over a rug or they sit on a chair and it breaks, that's called an innocent third party. And when they get hurt, the general liability covers them. So that's your general liability portion of the policy. And then our policy is also going to offer you with a option for what's an endorsement on our policy for the professional liability, which is also called E&O. The professional liability portion, instead of having to carry a completely separate policy, we include it on this one as an endorsement. The coverages do go up to $1 million in coverage. And then the professional liability portion, that's going to cover if basically there's an issue with you and a client and it comes down to if the client says that you financially owe them money at some point because the services provided weren't kind of as dictated, that's where that claim kind of comes in. Professional liability has like a little bit more of a scope than the general liability portion of it, but both of those coverages are included on your quote. And then as part of our quotes, we do include the RiskAssure risk management fee. So you'll see that included in your overall premium. And that's what gives you access to Joe and his team and the contracts that, you know, I feel like that is a huge, that's always utilized by our stagers, because that's the point where like they get a contract, they're not sure if what they covered is like fully encompassing everything. So that's a huge point that's included as part of our coverages. And then oftentimes what's not covered is that we just don't cover any rented autos. So if you rent any autos, those won't be covered. You would have to take the insurance that's offered by the carrier, or by the rental agent for the vehicle. But everything else, your inventory is always covered. And then, like I said, those general liability claims that could occur to your client's property is always going to be covered.
And so the services that primarily Dennis and I, but really my whole team provide in terms of the contract reviews, the risk management, the being on call, 24/7 to take questions about risk or about something that's going on, or reviewing leases or anything like that. That's all built into the program. That's not a la carte. And so when you buy insurance from us in this program, you get the whole thing. And that includes unlimited access to us and the people on my team to assist you with the agreements and any kind of risk management issues you might come up with. And certainly then, of course, with claims, any actual claims that come into the company under this program come directly to my desk first. And then I disperse it out to my team as we see fit. We do the investigation on it and everything in-house. So when you're dealing with us, really the unique aspect is that you're the people who actually own and run the company are right here. And you can reach us anytime. And we have a team in place to handle all the insurance questions. And then of course the risk management part, which primarily falls to Dennis and I, but that's all included with your premium. So you don't have to worry about paying for our services on the risk management side out of pocket. That's all covered by the program, which again makes it pretty unique in terms of I'm certain that there's nobody else out there that packages attorneys with your insurance to help you on the day-to-day and to help you develop your risk management platform. I'm going to skip around a little bit and go in the contracts and then maybe come back to some of the stuff. But just to kind of reiterate what Leah was talking about, we have the insurance programs and the risk management. Those things really have to work together. You can be covered sufficiently, but if you also don't have tools in place to insulate you from liability, as was said in the beginning of the program, then you run the risk of having a bigger problem than just an upset client or some damaged equipment. And so the two things need to work together in unison to be able to respond to any of the needs you might have. The insurance is good, but it's also helpful to be able to prevent those claims from hitting your policy, because that's what helps keep your premium down. And so on the risk management side, these are the things we provide. Again, this is all part of the program and free. We develop state-specific service contracts for every state in the country. So any of our insureds that either don't like their documents or have found their documents to be insufficient, or they're presented to us and we suggest they might be insufficient, we have form contracts ready to go already, that you really just need to put your logo on it, your contact information, and it's ready to be used with a client, on day one. We also develop subcontractor agreements. I'm going to talk about that in a little more detail in a second. We do occasionally some educational newsletters and webinars or articles. I think I just did one for RISA, but I can't remember how long ago, but they should have just posted it recently. We also have a pre-claim assistance hotline. A lot of people are afraid to call their insurance carrier when they have a problem because they're worried about their rates going up, or they have too many claims on the policy and will they be insurable? And when you're trying to run a business, that's hugely important. The last thing you want to do is be out there, without that security blanket of your insurance. And so we make ourselves available for things before they become claims. If you have an irate client, you can call us and talk to us. It might not be a claim on your policy, but it might be something we can actually help you diffuse. And so that's really what we're here to do. And then, of course, pre-claim assistance consultation. If you do have a claim, you work with us, really with Dennis and I, from beginning to end on that claim. You'll always be dealing with the same people, no matter when you have the claim and what type of claim it is under our program. And so that's me from many years ago, and definitely some gray streaks have arrived since then. But so this is generally the work I do. That we analyze your business documents, we review those. You have access to us throughout the year. Then, of course, we provide the claims assistance. And so, there's some universal things about service agreements that apply almost to any profession. It's the agreement between you and your clients. It has to let your clients know what you're going to do, and perhaps more importantly, what you're not going to do. Most people who buy and sell houses do it once or twice in their lifetime. Some more. I know our stager, designer, and decorator insureds deal with mostly more sophisticated sellers of real estate than the average person. And you can tell the level of sophistication because they know how important your work is to making that property sell. And so because you're dealing with a more sophisticated client, we don't get the routine types of claims that you might imagine. But you are going to have occasions perhaps where you have an irate client. And so it's better if you have that agreement in place that really lays out exactly what you're going to do and what you're not going to do, more importantly. The ideal of the agreement and what its value is to you is that it either has to protect you from litigation and or provide you with some defenses to liability. I'm going to talk about those in a second. Your contract needs to be easy to read. The average American reads at a 7th to 8th grade reading level. And so while you're not producing a report many pages to detail your findings and things like an engineer or architect would, but your agreement has to be able to be understood by the average person. And so when we see agreements that come in, a lot of the errors that we see are, too much legalese, for lack of a better word. I mean, you would think somebody that's made, their entire life's work about, telling you how important the contracts I write are, but a lot of lawyers are way more verbose than me. And we do get a lot of agreements that, it's a jumble of legal terms and Latin and everything under the sun. And, your reader needs to focus on the things that are important. And when you add too much noise in the agreement as compared to the things that are really important, it just creates confusion in the reader. It allows their mind to wander, and maybe they don't fully understand what they're buying, and more importantly, again, what they're not buying. And it can't be unconscionable. That's just a fancy legal word for unfair. When a court is asked to evaluate an agreement, particularly when you're dealing with a professional and a consumer, the court's going to be looking to make sure that the agreement isn't too one-sided or unfair to that person. And you know, I know we live in the United States, and people are free to enter into contracts pretty much for anything that's not illegal. But a court will still step in and change or modify the terms of that written agreement as they see fit, in the instance that the contract is deemed to be unconscionable or unfair, again, to the consumers, where they're mostly looking. And most consumer protection laws and regulations are geared to protect that consumer. They're not there to help the business. And then your agreement should be laid out, you know, and I would imagine this group can respect this more than most. It needs to be laid out in a way that is uniform and consistent and makes sense to the reader. And the layout can be just as important as the words that are used in the agreement. It needs to direct the reader's attention to important parts of the agreement. And in some cases, we need to set those parts off from the other language using boldface type or underlines or italics, or some way that the reader, in looking through this document, their attention is going to be drawn to that particular provision. And that's what we try to do. We try to basically, for lack of a better term, idiot-proof the agreement so that any consumer can easily read and understand it and see what they're agreeing to, most importantly. Now, a good rule of thumb with the agreements is to get them out at least one business day before the job starts. Now, most of our insureds are very good about that because there's a lot of planning that has to go into the work you provide. And so the agreements are, in most cases, usually signed in advance of any of your stage inventory being delivered to the property, or any work or any meetings at the property. Usually we have that agreement in place prior, but it's super important that that's done before you start your work. Once you get down with your client to here's what you're asking us to do, at that point there should be a written agreement in place and signed by your client, so that there's no confusion as to what's going to be done and not done before you start your work. Once you start the services and then add the agreement in, some courts might say, well, you know, they didn't really know what they were getting until you already started the work and it was too late. And so they may strike portions of the agreement for that reason. And so we want to make sure that your client has that in sufficient time to review it with their attorney or their agent if need be, and to comment on it or to ask you questions about it. If you can manage that and get it out to them in advance of everything, it really eliminates their ability to try to wiggle out of those terms by saying, why, you know, this was just shoved in front of me, I didn't know what I was signing, etc. And write for your target audience, you know, write for a 13 or 14-year-old. That's what we tried to do with the agreements as best that we can, given the restrictions of the law. You want to stay away from any language that might be confusing to the reader that they don't understand, but that's specific to the house or to your business. We want to always use common English words as much as we can in the agreement so that it can reach every reader, not just a certain section of readers. And then, as I mentioned, the average American reads at a 7th, 8th grade reading level. I'm going to tell you, in some cases during my day, because I also deal with all of our claims for our home inspector program, I'm thinking that might be more like 4th or 5th grade, but we're going to be generous and say 7th, 8th grade reading level here. And then there's your audience. So if they can understand your agreement, you're probably in good shape. Some basic things that need to be in every agreement. The price of the services are hugely important. It's not an agreement unless there's a price in there that they have to pay. A description of the scope of the services. Now, sometimes that's difficult to really put in the words because what they're really buying is here. You know, you have inventory and everything, but it's what's in your mind and what you perceive and lay out and what you know from your experience will be inviting and good for buyers to see. That's not something that really translates well to words other than to say, I'm going to professionally stage your home, or I'm going to professionally decorate your home. And so in that situation, sometimes that's really all there is. But you want to try to be as specific as you can where you can be. Your client's name and address should always be on the agreement, so there's no confusion of the parties to the agreement. It should always have the address of the property to be staged. All of your clients may not live at the property, but it's important that information be there. And then, of course, the start and end date of the services, which again is critical for you in terms of if you are bringing staged inventory to the site, how long they're going to keep that property. Because I've had, in the last couple of years, I've had several insureds of ours on the designer and decorator and stager side who have come to me with a problem because they can't get their stuff out of the house. Whether it's the seller or their client just, goes out of the country, or their agent has lost control of the situation, whatever the case may be. I've had it happen multiple times. I've also had insureds call me in a panic and say, the agent for my client is telling me the stuff has to be out of there in 12 hours or they're going to put it on the street. And so we're not always dealing with the best people or the best intentions. But the start and end date is critical because, again, we want to make sure that there's an understanding there that this stuff is no longer going to be used for them after X date, unless, of course, additional arrangements are made. And so in addition to kind of talking about the scope of the services and what needs to be in agreement, we need to talk about exclusions, because we want to tell the client up front some of the things that aren't going to be involved in any of the work that you're going to do. You might have limitations caused by the layout or design of the property that need to be incorporated into that agreement. There may be inherent safety issues about the property. There's no handrail going up the stairs, things like that. There's trip hazards. Those are the types of things that you're not going to be responsible for, because you're not going to be there controlling that site on a 24-hour basis. You don't want to be responsible, and you want to exclude liability for any work by third parties. And that can be third parties you bring to the transaction, or it can be third parties that another party in the real estate transaction has brought to the site. But either way, you want to make sure in your agreement that it's very clear that you're not responsible for the work of anybody but you, and or the people you directly pay as employees, or people that you've subcontracted and you're taking responsibility for them, versus bringing, let's say, a moving company into the mix. And then, of course, any conditions or deficiencies, you're not there to be a home inspector, an appraiser, or an agent. And so you don't want to be responsible for any conditions or identifying any conditions or deficiencies for your client. And again, you'd be surprised how because people don't do this repeatedly over and over again, how little they actually understand of what the limitations are on your scope of work. And then, of course, there may be exclusions for this particular job. Hey, I only want you to stage the living room and dining room. I don't want to do anything else. We're happy with the way the rest of the place looks. That's the type of thing that needs to be in your agreement up front, so it's understood that only certain areas of the house are going to be staged. And then we also have defensive clauses in these agreements, which we use to insulate you from liability. And some of them include a liquidated damages clause. What that means is that in the agreement, it says that if you allege I was negligent in providing these services, your damages are limited to the fees you paid me for the services. And in a lot of states, we can use this. And so what that does is it limits that universe and that amount of money that somebody can make a claim for, and caps it at the cost of your services. Now, they're not usable in every state in the country. In some states, they're not enforced. But we, in advanced planning, know which states they are and which states will use them and which states won't. But it's a powerful tool to be able to at least know that no matter what happens, the best the client's going to be able to do is get a refund of their money. Indemnity provisions are important. If you're putting your things at somebody's site and you don't have control over the site, you want them to indemnify you if there's any damage to your stuff. In addition, you want to be indemnified if some third party that your client or their agent brought to the transaction damages your stuff. You're going to want the people who are in control of that area to indemnify you, to pay you and make you whole for your loss. There should be a provision of your agreement that sets a time period for when they can actually make a claim. In some states, you've probably heard the term statute of limitations. In some states, that time period that somebody can sue you is up to 6 years, and some 10 years for a breach of contract. And so we want to cut that world off. We've had a lot of success limiting that to 1 year in the agreement. And that, again, buys you some certainty. It also helps us keep the insurance premiums down because we know we have an endpoint, that there's not 10 years worth of possible claims hanging out there in the ether waiting to pop up. And then, of course, arbitration, that's kind of a business decision, and I'll talk about that in a little more detail, but you may have a clause in the agreement that requires your client to bring a claim against you outside of the court system. And there's many advantages to that, not the least of which is it's out of the court system. But more importantly, with arbitration, you also can't appeal. So if the arbitrator makes a mistake about the application of the law or about the facts of your case, there's nowhere else for you to go. If the case is in court, we have other courts above the court you're in that you can appeal to if there's been a mistake by the judge under certain circumstances. But you can't do that in arbitration. And so that's why arbitration is a little tricky. I personally don't like it, but I have a lot of our insureds who do. And so we'll always put the clause in their agreements for them. And certainly anybody that wants one, we have a clause and we have a list of suggested arbitration providers that we found, I've been litigating for 25 years, that I found to be the most fair in their application of things and even-handed. The other big ticket item with agreements are subcontractor agreements. You know, a lot of real estate professionals are very good about getting that initial agreement with their actual client. You know, in your case, probably the homeowner, and it may be the agent. But there's other people that you may be working with to get your job accomplished. The easiest one obviously would be movers, right? That you're going to hire a third-party moving company to bring your staged items from your warehouse or from wherever to the property. Well, you need to have separate agreements with the people who are providing those services to you. Because if you don't have a separate agreement with them, they're under no obligation to protect you in the event that they cause a problem that then you're sued for. And so you should have a separate subcontractor agreement with any subcontractors you work with, and anybody that provides services to you. In terms of insurance, these are generally required. What the ideal subcontractor agreement will do is it'll lay out the scope of work that sub's going to do for you, but more importantly, it has some built-in protections there. One of which, again, we go back to the term indemnity that I used earlier. You want any subcontractor working for you that you're bringing on site to indemnify you and hold you harmless from any claims related to their work. And so if you have a written agreement with that language in place, they now have a legal obligation to you that if they break something or somebody gets hurt because they leave something somewhere, whatever the case may be, that if you get sued or named in a claim because of work they did, that they will step in and defend you, which means either hire counsel to represent you or defend you in some other fashion, and also to indemnify you. And that means insulate you from any judgment by that third party making the claim. If you don't have that written agreement, they have no obligation to do any of that. And so that needs to be in writing. And more importantly, you also want to be named an additional insured on their policy and make sure that they are carrying insurance. It's important. You know, somebody can agree to defend and indemnify you all day long, but if they don't have the money to do that, or they don't have insurance in place that will do that, that promise is empty. It's meaningless. And so what we want to make sure in that subcontractor agreement is the subcontractor you're using has their own insurance that has named you as an additional insured. If they don't have that agreement with you, their policy may not respond to a claim related to their services in the transaction for which you brought them in to help your clients. And so there has to be that written agreement with them as well. Now, in addition to the service agreements we provide for all of our insureds, we also provide subcontractor agreements that have been written by us and vetted and can be amended and switched around to meet your specific needs.
For
The other part, oh, go ahead.
Joe, just to jump in here really quick, to clarify the insurance that's required by the subcontractor, we get asked about this a lot. The insurance requirements are that they carry their own general liability policy and their own workers' compensation policy. Oftentimes people say like, well, they don't have insurance, they work for me sometimes. Either way, they need to carry their own general liability and workers' comp policy to make sure that you're fully protected when they come onto the job site working under you.
That's a good point, Leah. Thanks. And in addition to that, too, keep in mind, as Leah talked about in the beginning, you know, that there's a big difference between general liability and errors and omissions insurances. General liability covers accidents. Errors and omissions covers negligent performance of the actual services. Now, you may be bringing somebody into the transaction that is providing more of a professional service like you're providing rather than a labor-oriented service. And so in that situation, in addition to the general liability and workers' comp, you want to make sure they have errors and omissions insurance, because if they don't, general liability isn't going to cover a claim that they were negligent in providing the services. It's only going to cover a claim if they cause damage or have an accident. And so that's an important distinction to keep in mind as well.
Mm-hmm.
Again, we did talk. I talked a little bit about the COVID-19, but we do have specific agreements that relate to this and set out the protections that may need to be afforded either for you or for your clients or somebody else involved in the transaction. But we provide specific documents that lay out everybody's responsibilities relative to COVID in terms of the work you're doing. But I'm not going to spend any time on it really here because I think we've all been inundated with this for the last 3 years, and we know that if you do need to protect yourself or your client needs to protect themselves, you know, that you need to make sure those pieces are in place before you start the work. So this is more the contact information for us in terms of what we do. But I also, you know, wanted to leave enough time here for the group to ask questions and really any questions you might want to ask about the insurance product or about the risk management part of our operation, or just anything general. We're happy to help you as much as we can, but I always like to leave about 15 or 20 minutes to cover those in more detail. And if we don't have a lot of questions, I can show you some examples of some agreements and things that we've received.
I do have a question regarding the signed contract. Is it sufficient enough to have them sign it and then like take a photograph and send it to you?
Yeah, it actually is. You know, I always we get asked this all the time because it's an important question. Is, you know, can I accept an electronic signature or a fax signature or, you know, really anything except wet ink on an agreement? And the answer is certainly yes. You know, for the last 10 or 15 years before I stopped in the private practice of law and took the position I have with Elite in Villanova, I hadn't signed anything with a pen in forever. And so the legal system has always been very receptive to, you know, electronic and or scanned or any other signature other than fresh ink. So as long as you have proof that they signed it, that's going to be good enough, and that will be enforceable.
Right.
There's also, you know, other than that, some people use DocuSign, but there's products out there that also, if you're doing electronic signature, that will verify the IP address of the person who signed it. And that's how we prove that it was that person and not like their 10-year-old messing around on their computer or, you know, somebody accidentally signed it for them. But either electronic signature, a photograph, a fax, anything where you can show that they signed that agreement is going to be admissible and it is going to be enforceable.
Super, thank you.
Mm-hmm.
I have a
Joe?
question. Oh, sorry. Go ahead, Bonnie.
Joe, I just wondered if you could define indemnity a little bit.
Yeah, sure, absolutely. So your insurance policy, it's easier to explain in the insurance context, and then that kind of you can superimpose that over the agreements. But your insurance policy provides you with two things. It provides a defense to you, and it provides indemnity. The defense is that if you get sued, your policy pays for the lawyer we hire in your area to represent you in that lawsuit. Or when we were talking about the subcontractors, what we mean by they have to defend and indemnify you is the defense part is to hire and pay for your attorney to represent you, pay the experts in the case, whatever the case may be, but to insulate you from those costs. Indemnity is money paid to you to satisfy a judgment or a claim. So in the sense of insurance, what that means is the defense part, you know, we've hired the lawyer and they're representing you, but we had the trial and the jury decided to award damages to the people suing you. The policy indemnifies you against that judgment by paying the judgment on your behalf out of the proceeds of the policy. Similarly, when we talk about subcontractors, the indemnity part of that means that if there is a judgment entered against you as a result of the work by that sub, that they are going to indemnify you, and that means they are going to pay that judgment on your behalf. So indemnity is kind of, think of indemnity as the financial part of it when we talk about insurance or contracts. That's the money that somebody's going to pay to settle a case or pay damages. And the defense part is representing you, or, you know, if it's not a litigated matter and you're working with us and we're writing letters on your behalf or whatever the case may be, that's defense. But indemnity is basically paying a judgment on behalf of somebody else.
Thank you.
You're welcome.
Okay, so my question is, I carry my own inventory.
Yep.
And last year I probably spent an easy 50-60,000 rebuilding my inventory.
Mhm.
I didn't change my insurance policy last year, which I'm thinking is pretty stupid because I added a lot more. But right now I live in Massachusetts and my storage facility is a separate place in Massachusetts. I'm going to be moving to Maine,
Mhm.
but my storage and my inventory will remain in Mass.
Mhm.
Does that create a different kind of issue for insurances and legalities or anything?
No, not, it doesn't really matter how far you're away from your stuff, as long as we know what that stuff is, right? And in the case of the insurance products we provide, also important, we know where the stuff is, right? And so in what state. But it doesn't make you any more or less insurable or change your rates if your stuff is being stored off-site in one state and you're residing in another. But it does bring up another point, which is, that relationship between you and that storage facility, or between you and that landlord you might have if it's a private facility. That's something that we deal with a lot on the risk management side with our insureds. And just like the subcontractors, we want an agreement in place that helps insulate you. Well, we want the same thing from the people that are keeping your stuff safe and secure, right? And now, in that situation, you're not going to have a whole lot of bargaining room with a storage facility, for example, because they're kind of like they're Microsoft. They're a big corporation usually that owns many of those sites, and these agreements are not something that they're willing to negotiate, but some are. And so in terms of the storage facility, or if you're renting private space to keep your stuff, one of the things you want to keep in mind is, does your landlord have the appropriate insurance in place? Or does the storage facility provide any indemnity to you if your stuff burns in a fire or somebody breaks in and rips the place off? A lot of those agreements are very onerous and one-sided in terms of the facility, where they're going to try to disclaim any responsibility for anything that happens there. But you want to make sure you read that agreement very carefully and ask questions if you have any questions about it, because that can be just as important as your client services agreement. We had one insured who had the agreement wasn't really sound related to them and their landlord, and the claim ended up being about $400,000 because they had a fire loss. And the carrier, in that case, it wasn't our captive carrier. We used to place all of our risk with a couple of the big insurance companies before we built our own 3 years ago. And they fought us on that claim and tried to say that, well, the insured should have had things in place or had insulation in place for them in the event of the landlord's negligence. But we ended up actually getting the claim paid. But that's the kind of thing, again, where you want to have some agreement in place that if my stuff is completely destroyed, what are you going to do about it? Or is the property secure? Is the alarm system monitored? Are people checking the fences and the gates? All that kind of stuff is important.
Okay. I have one more question. Question about subcontractors. So I told you that we have two parts to our business. We have the home painting, renovation, whatever, and then we have the staging. The people who work for us are 1099 contractors. And they're all friends of ours. Like, it's people that we see every day, work with every day. But I am 95% sure that none of them have their own security policy, or whatever you want to call, protecting them, their own insurance. So that's something that they would have to have or should have.
Yeah. So your policy is not going to provide coverage for those subs unless, you've identified that you use these subcontractors and that you have the written subcontractor agreement with that sub. In that situation, our policy would step in for you, provided there's a written agreement. But I'm going to tell you, the unfortunate thing about the world we live in is everybody's friends and happy until money comes into the mix. And the people you think very well can change very much when they think they have a claim. And so it's sometimes it seems a little bit like, especially if you've been dealing with somebody, at arm's length for many years, it might seem a little distasteful or out of place to say, hey, I know we've had this great relationship and I know you'll never do anything to hurt me, but I need you to sign this agreement for risk purposes and business purposes. That's not an easy conversation to have in a lot of situations, but it's an important one. And just as important as them having liability insurance, the work comp is just as important, because there's a lot of opportunities in your business for people to become injured, to suffer a bodily injury, you know, a back injury, moving stuff, or trip and fall, or whatever the case may be. And so you want to make sure that they're insulating themselves. And you can ask them for a certificate of insurance. But the key there, though, is to be named an additional insured and have that written agreement where they have to indemnify you and defend you in the case of a claim. Those things need to be in writing in a separate agreement. They're just not going to be assumed.
Okay. All right. Just gives me more homework. Got it.
Well, it's homework we can help you with, though. That's the one good thing. You're allowed to cheat on your homework if you have us in your corner. So
Excellent.
we're happy to do the test prep for you.
Okay.
But yeah, this is the kind, and so these are the kind of things, you know, that we're talking about here during this webinar. These are the kind of calls and things that we take all the time. And this is kind of what our purpose is with regard to this program, is to be there and be a trusted partner with you in terms of your risk management, and to help you with manage all the risk for all these other relationships as well. You know, that's really our specialty, and something we pride ourselves on.
Okay. That sounds great. Thank you.
You're welcome.
Lori, I do want to add in too, for your policy, you should be covered anywhere in the continental United States. So regardless, if you live in Maine and your inventory is in a different state, you should be covered across those states. And then it's just always important to make sure that those addresses are updated with that inventory amount, because oftentimes we see insureds come back to us and they say, oh, we haven't updated it in this and however many years, now our inventory is worth 100,000. Your insurance company's only gonna pay out, is only gonna cover the limit as to what's on the policy. So when you work so hard to build your inventory up, you want to make sure that it's just properly covered.
And I honestly can't tell you the last time I read my policy, so.
No, it's so easy to fall through the cracks. I feel like it's that one thing that everyone pushes down the to-do list, but once you get it done, it's definitely feels a lot better.
Okay. Great, thank you.
So with the last few minutes we have here, I thought it might be good to just show you kind of what an agreement might look like. And so just give me a second here and I'm going to put that up for you.
While you're pulling that up, Joe, can I ask a quick question?
Oh,
please?
absolutely, yes.
Sure. So when we're kind of going through this process, we see a lot of names, you know, like Nova Insurance or Villanova or Elite PNC, Clear Blue. Can you, is there a way to kind of describe, like, do we think about it like a mortgage where, you know, there's like the general holding group and then it's sold off to an insurance company, or how does that work? And how do we make sense of all the different names we see from a Pennex to a Nova to a Villanova?
Sure. Yeah, it's a lot, right? And so generally speaking, Villanova Insurance Partners is our parent company, and Villanova Insurance Partners owns Elite MGA, which is the managing general agent for the Stager Designers and Decorators program. And it owns Elite P&C, which is our property and casualty company that sells personal lines and commercial business lines. Inspector Claim Management is our sub company that handles all the third-party administration and the claims management and risk management, and then Pennex. And so we bought Pennex in 2019 from Judy Phobes, who had a very long, successful relationship with Risa. We brought Judy into the fold and worked with her to develop the program for ourselves before she retired. And so Pennex, we bought and owned Pennex, and that's how we got into the staging and designer and decorator insurance business. But Villanova is our parent company that owns everything. The properties are actually sold through Elite MGA and Elite P&C, but we're all the same happy company. And because everything's owned by Villanova Insurance Partners, you know, we have central control over all these aspects of the business. But each party, each piece of that network is there to serve a different purpose relative to insurance. But Villanova Insurance Partners is the parent. Penn X, Elite PNC, Elite MGA, it's all basically the same company.
Awesome. Thank you. That was so helpful.
You're welcome. Now, Clear Blue is our partner on the insurance side. And so because we own the insurance risk, we partner with Clear Blue, so we use their policy form. And the reason we do that is because it's a very, very long process to go and take an actual insurance policy document and get it approved in every state in the country. So companies like Clear Blue provide the policy form that's already been approved, but we own the actual risk in the insurance. So if a claim is to be paid, we pay that claim out of our own funds, not by Clear Blue. But Clear Blue is what we call in our business fronting paper. And it just means that we're using their policy form for our insurance program. So they really don't have anything, they're not involved in any of this really in any way other than that they have the paper. All the claims decisions, all the pricing, what's covered, all that stuff is exclusively within our control. And so what we bring is, it's, in other words, if you have a claim, you're not calling somebody up in Chicago in a room full of 100 adjusters who are dealing with 30 different types of claims that day. You're only dealing with us, and we specialize in one thing, and that's real estate professionals. And so that's kind of what makes us unique and a little bit different than the other carriers you might come in contact with.
It's hugely comforting. Thank you.
Oh, you're welcome. Thank you. I was going to pop. You can see the agreement now, I hope. This is the form agreement that we put together for our insureds to use if they don't have an agreement or if they're just not real happy with theirs. And so I just got to move this window a little bit so I can see what I'm doing here. There we go. And so this is the form agreement that Dennis and I put together. And I want to call your attention to a couple paragraphs that we talked about and a couple we didn't real quick as we wind up here. And so this number 10 is that indemnity and hold harmless agreement. Now, this is between you and your client. And this is the agreement where your client agrees to defend and indemnify you if there's any damage to your things, if somebody else at the property that they bring in causes damage or an accident. That's what I'm talking about. And when I was talking about how you set apart the paragraphs, you'd be surprised how many contracts I get that aren't numbered, that the paragraphs cover multiple topics. Each paragraph should cover a unique part of the relationship. And there should be some way for your reader to be able to tell what's important. And so we put that indemnity and hold harmless in caps and bold because that is a critical thing. That's a provision where your client is giving up some rights or signing off on having some responsibility here. The other paragraph at the top, paragraph 8, if ideally, you're so proud of your work that you want to take pictures of your projects and use those to advertise your services to other people. And you want to make sure that you have an agreement in place with your client that lets you use those photographs. This can take many forms. This is just one that we created, but again, that's something that needs to be in your agreement. All these things that might come up where you need permissions from your client need to be in this agreement that you have signed. And then we have the no liability for third-party service providers there that I talked about. And then some of the other defensive clauses, limitation of liability, I talked about that. That's number 16 here. That's the clause I talked about where you cap the available damages at the cost of your services. And again, these aren't enforceable in every state, but we know which ones they are. And then I talked about the limitation on time to bring a legal action, which again is highlighted, differently than the other clauses to call the reader's insurance to it. But that's the clause I was talking about that caps the damages at 1 year, or caps the time to bring a claim to 1 year. And we, the other thing to keep in mind too is we laid this out to try to be as short as possible, but you never want to cut things that are important, in order to make the agreement a little bit shorter, particularly when most of these are delivered and read electronically now as opposed to otherwise. And then just one other quick thing that comes up a lot of times in questions, I'm calling your attention to paragraph 23, but there are some occasions where your end user client is the owner of the property, but you're being paid by the agent. And so you want to have some controls in place in the agreement to bind that agent to pay you, right? And so if you're in a situation where the end user, the owner of the property, is not paying the bill, but the real estate agent is, or any other party is paying the bills, you want to have a clause like 23 here in the agreement that binds them, in addition to your client, to be responsible for your fees and costs, and also to indemnify you and hold you harmless. And so we had to develop that as kind of a hybrid because, you know, every situation is a little bit unique. But this would then allow you to take payment from a third party other than your client, but still bind everybody to that same agreement. And that's also important. You can still bind your client to an agreement they sign, even if somebody else is paying. But if you want that third party payor to be responsible to you, you need to have something in your agreement that speaks to that. And so that's why we developed that clause. And again, this is an agreement that we freely give out to any of our insureds. Or we will take whatever you have that you're happy with and run it through the ringer and edit it and tell you where we think it could be improved or not, or if it can be cleaned up. And we do that again, that's all part of the services, and we can turn it around very quickly. So if you do have questions about your agreement, or if you're already insured with us and didn't know about this benefit, definitely let us know, because we want to make sure that you're getting full use of what you're paying for and that you're getting every benefit that we can possibly give you.
Joe, in the situation, number 23 here, if I'm doing the staging, my realtor is paying, but it's an occupied home, or whether it's occupied or not, I guess. Does this cover, sorry, my dog is going crazy. Does this cover that part of it?
Yeah, that's exactly what it's here to do, is that if your client is not paying, but they're going to still be the end user, and like you said, whether it's vacant or not, then this is the situation where if the realtor is going to pay you, this is what you want to have in the agreement, and have the realtor sign off on this. So you'll have a signature by your client as well as the realtor.
Okay, that's what I was wondering.
Yeah.
So
because
both of them sign it.
Yeah, that's exactly right. And so we put it, like in our agreement, you know, we put a separate sign there for them, that third party payor, whether it's the agent or somebody else. Sometimes it's an attorney. But either way, you want to make sure that the people who are agreeing to pay have signed off on this in addition to your client, so that if the payor, the third party, doesn't pony up the money, you can still collect it from your client, who really received the benefit of your services.
Okay, yeah, I've never done that before. I've only had whoever pays me sign it, so.
And that's obviously that's going to be the 90% of the time, that's going to be the transaction, but it did come up from time to time. And you hear all the time about the Constitution being a living document. Well, these have to be living documents as well, and they have to be changeable to fit certain situations or needs. And so we try to create something that would fit most of the situations. There's always going to be jobs that come up that are a little bit unique. And in those situations, we invite our insureds, you know, is there something special about this you need us to write in this agreement for this particular job? And we do that. Because again, every job can be unique and every client's going to be unique. And so we want to make sure that, you know, you're not just stuck with this document we created or the document you provided to us that we edited, but that we're also here for the times when we need to adjust that a little bit to make decisions on what we want to do and how we're going to do our jobs. And so we always make sure that we're, you know, we like to call ourselves agile, right? That we're available to jump from right onto your situation immediately and help you with that and make sure it's right before you go about your business.
That's
Hi
excellent.
guys. So well, let me put my video on. Hold on. Hi everyone. So when I bought Deb's business, I ended up signing up with Joe and worked with Joe and Leah, and they've been wonderful ever since I created all my contracts. So highly recommended. But I did have a quick question for Joe, which we can always talk about later on, because I don't know if this would apply to anyone else in the meeting. But for somebody that has inventory that rents to other stagers, I feel like I need to have some sort of contract for me and other stagers to protect my insurance. I mean, to protect my staging items.
That's a very, very good point. And we actually, I think probably since we worked on yours, we have a staging inventory lease agreement.
Mhm.
Oh,
Yeah, so you know what, if I forget, if you don't mind sending me an email, I'll send you that, and then let's make an appointment to go over a little bit and tweak it for what, because it's very basic, obviously, you know, it's kind of like the agreement I'm showing you, it's written for everybody. But I
Yeah,
have I have a staging and inventory lease agreement that I can give you.
okay, that would be perfect. Thank you.
And I'm glad you brought it up, because, and this is a good way to wind it up, is that's another critical piece, right? Really think about it like this. Any of the parties that you're transacting money with and getting things from or giving things to, you need to have something in writing related to that. And the audience agrees. So there you go. I miss those days. I really do. My youngest is going to be 15 in a month, and you do really miss it as they get older.
Now it goes by quick, I heard.
But I'm hoping the 30-year-old gives me some grandchildren at some point, so I can at least
There you go.
I can have the good experience and still be able to hand them off at the end of the day. I was promised that at some point that would be my life, so I'm hoping that's the case. But yeah, it's another critical written agreement that you should have in place. If you're leasing any of your stuff out, you should really have that agreement in place.
Awesome. Thank you. I'll send you an
Thank you,
email.
Ash. Thank you. Okay. If nobody has any other questions, I just wanted to put up the contact information again there so that you have it. And there we go.
Yeah, and that
So
link will take you to our website where you can submit your application. And then once we receive the application, you'll get a quote directly from me. And then we can schedule a time to really review the quote that we offer, but also review your current coverages to make sure it's like a full apples to apples comparison. So you fully understand exactly what you're covered for. And then if you choose to move forward from there, that's when you get all the contracts and all of Joe's contact information moving forward.
Wonderful. Thanks, Leah.
Yeah.
well, I hope it was informative. I know it's a lot of kind of legal information to throw into an hour, and we're always available, whether you're insured or not. If you were on the presentation today and have a follow-up question, a lot of times we have questions maybe we don't want to ask in front of the group for whatever reason.
Mhm.
If you reach out, Leah, you'll get the Reassure help desk email, right?
Yep, I'll get the help desk email,
So
and then
if-
I'll
if-
also
yeah.
send
ahead.
our contact information directly to the organizers.
Yeah, and so that way, if there's a question you wanted to ask me, you can send it to the Reassure help desk email there, and Leah will make sure it gets to Dennis or I to give you a response. And that even if you're not uninsured and you have a question you wanted to ask and didn't get a chance to, by all means, feel free. I'd much rather do that than talk to the claimants I have to talk to at some point today. So I'd much rather have a conversation with you instead.
Well, we thank you all so very, very much. It was great for you to join us and fill us in on all this. And I know that I'm probably not alone in needing to look into these services. So,
Well, we appreciate it. Whatever we can do to help you, we're here to protect your business and to help you stay successful. That if we're doing that, we're accomplishing our stated goal. And so if we can help you in any way, please let us know. We're happy to help.
awesome. Thank you. Thank you so
Joe.
much.
All right. Thanks,
Thank you.
everybody.
Thank you for your time.
Thank you. Of course.
Bye, guys.
you.
Take care.
Bonnie, do you want to, crazy. Bonnie, do you want to let them know your question or what we were just talking
Yeah.
about?
Yeah, for anyone that stayed on, quite a few years ago, I remember we had a discussion at Robin's husband's place up in Massachusetts, wherever the heck he is, I forget. And we brought our staging contracts in. I think that there were 4 or 5 people that said, happy to share these with everybody. We went over a couple of key points because sometimes you know what you want to say and you don't know how to say it. And like Joe said today, you want it to be simple and concise that even somebody younger can understand. And just by sharing, I think Robin put hers out there and Pam did, I did. Some of the girls that were new were saying, oh my gosh, I hadn't even thought of that. Well, I was in that position too for a while. And it wasn't until one of the veteran stagers said, this happened to me and this is some of the content that I put in. It really helps a lot. If anybody's interested, I'm more than happy to share what I have for a contract. If anybody else is willing to share, I think it just gives us pointers on how to write it, or how to explore it, because everybody's business model is a little bit different. So just wanted to put it out there. I'm happy to throw mine out there if anyone would like.
Okay, yeah, I'll do the same thing too. If anybody has questions on it. I do think at this point, I'm going to talk to their team. It just, from my perspective, having so much new inventory, going state to state, I know he said that's not a big deal for them, but it is for me.
Yeah.
I want to make sure I'm covered all the way around.
And I agree with you. I think it's probably time for me to look into having somebody really go over it with a fine tooth comb, because I've had a realtor that is becoming the client, and the realtor wants to pay for the staging. And she pretty much said to me the other day when I sent her DocuSign, there's about 6 key points that I don't feel responsible for. It really should be the seller.
Oh boy.
And I'm saying, yes, the seller is not paying for the staging. And although the house is vacant, like, I need somebody to be responsible for this. And she
Right.
said, yeah, I just don't really feel like some of the things apply to me. So I just didn't initial them.
Yeah, so, and
She's
I
just such a
feel like
great-
in that case, she or he should go to the client and say, I'm paying for this part
Right.
is on you.
Right.
And like,
Right.
I never, ever, I have a lot of realtors who pay the staging. I've never had the client sign just them,
Right.
and it's like, it makes
And I don't
perfect
want
sense.
to, and
Their
I don't want
house.
to push it, but like Joe was saying, for God's sakes, like, what if something does happen? Like,
It's
yeah,
on us.
you're kind of friends with the realtor at this point, but
Right.
I have to protect myself. And hey, guess what? One of the clauses was, could I please have the deck cleared in case of snow so I can carry a sofa through the back instead of through the front? And she's saying, maybe your son can come down and shovel. And I'm just like, all right, I'm pretty sure she initialed that.
Oh
So
my
I am not going to carry sofas up the front stairs when they can come in through the back porch. You want that porch cleared anyway for an open house. So that's a client's responsibility. It's not my responsibility to snow blow for them, but that's case in point. Okay. I just feel like some of these things are something that maybe a new stager or even a seasoned stager or somebody that's been in design and now is moving over to staging saying, I never thought of that. So I just wanted to volunteer. I'm happy to put mine out there, and then
Yeah,
I'll have.
I would love to see it, Bonnie, if you could share
Yeah.
it. I would love
Yeah.
to see yours.
Sure.
Yeah, when we did the switch, I had gotten quotes from both Debbie's previous insurance agent and then with Joe, and they came in much lower. I was shocked. I thought that they were going to be more expensive than Debbie's
Yeah.
existing. And so I was like, well, that's a no-brainer since they came in much lower than her existing, and also they're so specialized in staging, like they really know what I'm doing. So it was a no-brainer for me because I was starting out from scratch. But if anyone's insurance is coming up to, maybe expire or something and you're interested, they've been wonderful. I've had many questions for them. I've reached out, sent an email or had a phone call with them. And then, like I said, Joe and I had a meeting and he pretty much drafted up my entire contract for me specifically for like everything that I do and with my like owning my furniture and whatnot. But yeah, Lynn, like it's not just with you, but there was another stager that is going to be renting from me and was asking if there's a contract. And I'm like, oh my gosh, I probably should have a contract. I never even thought about that. So I'm going to ask him and see kind of what that entails, because
Good idea. Yep.
I mean, the people that I know, like me and Lynn, I mean, we're very flexible. It is what it is. But if there's a new stager that comes that I don't know that well, I can't,
Right.
I gotta protect myself.
Yep.
Yeah, I'm totally happy to sign something. Totally happy. I agree.
Yeah.
And we've had realtors ask to rent stuff for,
Yep,
because they're
exactly.
staging on their own or whatever.
Yeah.
And I don't have any contracts with them for that. I just
Yeah.
never thought about it.
I know.
You know, paperwork is not my strong suit.
Yeah. How many of you use other movers, or do you move stuff yourself?
We do ourselves.
You do it yourself, like you
Mhm.
and Mike will do it, or you and your
My
1099?
my team will do it, yeah.
Yeah.
My subcontractors who aren't insured, apparently.
Right. Right. Well, so like my mover is a 1099, and God, the whole insurance thing is such a pain in the butt, you know, like I guess it is just part of the gig.
Yeah. It's a lot. It's a lot. So, whatever.
This was a
We
good
learned.
subject to work on though, Laurie. Good
Yeah.
subject.
You know what it is? I remembered after we had this meeting last year, I had already known that I was buying the business and I was going to have to get my insurance. And this was like a huge fire under my butt. I was like, oh God, I got to have my stuff in order. I got to be protected. But yeah, I mean, it's worth to at least just get a quote from them because I thought they were very affordable.
Yeah.
And I agree with Ashley. I've actually been using them for a couple of years now, actually since I started. And I feel like they're very responsive. They answer my questions. And this is a great meeting because I'm going to send my contract over to them because I'm sure it's light. Because I can't get anyone to read it, you know, like I have some very basic things in there and I can tell people don't, I mean, and I shouldn't indict other people because I'm not great at reading my own. So anyway, the long and short of it is I'm going to send mine over to them and make sure it's not missing key paragraphs or things that, you know, and they gave me kind of a pared down version, but I have a feeling that I need to go back and say, is this adequate?
Yeah. Bonnie said she's sorry she left so quickly. She just lost power.
Oh, no. I know. My husband just got home from work. He went in last night at 8 and got in at 7. He goes back in at 3. It'll
Ugh.
be a long week.
Yep. Yeah, it's crazy. I didn't expect this, but it is what it is.
How much
So-
are you getting down there?
I think we've got at least 8 inches right now.
Yeah.
Oh
What
my
are you guys supposed to get?
I thought they said 10 to 14, but it's coming down really hard. Like it doesn't look like it's gonna let up anytime soon.
Yeah.
So
Yes.
I wish my drone photography was today because the yard looks great.
Oh my gosh.
We're gonna go up on the second floor porch and take some pictures.
All right. There you go.
Oh, yeah. Oh, yeah.
How's everybody doing?
I wouldn't be able to fly today because of the weather.
Oh,
Right.
all right. Well, there's that.
That's why I suggest, you know, we either go to the weekend or we do it now.
Yeah,
This is gonna be a crappy week.
yeah, yep, it is.
Beth, have I met you before? I can't zoom in on your face.
Oh, yeah, no, I'm pretty new to staging, so this was a great meeting. It's exactly what I need to get started. And thanks
Oh,
everyone for all your input. Yeah.
Beth, where are you from?
I'm from Connecticut, from Essex, Connecticut.
Oh,
And I
awesome.
have, yeah, it's a shoreline. I have no snow and I'm a skier, so hearing about all the snow is like totally exciting.
Oh, feel free, come on up.
Yeah, I'm thinking that. And actually,
we-
while I have you guys, I need to pay my chapter dues. So if someone can send me wherever I need to send my check and application.
Yeah. Lynn can
Lynn,
do
is
that for you.
Okay, yeah, just shoot me an email or tell me where to send it. I have it sitting right here and it's been on my to-do list for a while, so.
Okay. Well,
Okay.
listen, it was great, everyone. Thank you.
Yeah, this was awesome.
We'll catch up soon.
All right. Stay safe,
Sounds
everyone.
Bye,
good.
guys.
Stay safe,
Bye.
everyone.
Take care,
Enjoy the
everyone.
snow.
Thanks. Bye-bye.